Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Today I'm at Southport Magistrates Court. Client was charged with repeat disqualified driving. It was his third disqualified driving offence in an 18-month period. Basically, disqualified driving is a contempt of court offence. When a person is disqualified, it's as a result of a court ordering that they no longer drive. So whether it's drink driving or whatever else, if you go to court and the court orders that you as an individual are not to drive for a set period, and then you are caught driving, it's a breach of a court order. So the courts don't take lightly to these breaches. It's not like suspended driving where Queensland Transport sent you a letter and you didn't get it. You as an individual have been told by a magistrate, do not drive, and if you're caught, they basically see red. The first time you do it, you might get away with a disqualification and fine. The second time you do it, you might get away with a disqualification and fine, but people do go to jail, like actually go to jail for their third and subsequent offence, particularly if there's a lot of offending in a very short window. As I said, my client was facing his third disqualified driving charge in as little as 18 months. Accordingly, my job wasn't about saving his licence, it was about making sure he doesn't go to jail. As a part of that, I had the matter listed for a lengthy plea, so we didn't deal with it on the first court date. We adjourned it for a lengthy plea. There's a special court in Southport where if you're going to take longer than a few minutes to deal with the matter, and you need to take your time and guide the magistrate through lengthy case materials and submissions and legislation, etc., they don't want you to clog up a busy court, so they'll set it for a lengthy plea. That way the magistrate can take their time considering my submissions and the documents and information that I put to them. With regard to those submissions, I drafted, it was about 8 pages of case law of persons with repeat disqualified driving where they either didn't physically go to jail, meaning they got immediate parole or a wholly suspended sentence or something like that, or they got penalties that weren't as severe as what is normally the case for repeat disqualified driving. I got my client to attend a reformatory course. There's a few courses that we give our clients the option of choosing. One of them goes for 3 weeks. That's the longest of the courses available. We got him to do that one because, when it's all about me keeping you out of jail, we need you to go to more than one evening of reformatory education. So he did this over 3 nights. I drafted affidavit materials for him to sign based on what he told me he learned from the course, got him to get character references. But at the core of this matter was the written submissions of the case law that I'd prepared earlier. Met my client at court this morning, ran through what was going to happen, my submissions, the procedure, etc. Basically, I took the magistrate straight to the written submissions as a starting point, the case law, and said, Your Honour, here's a series of examples of persons who have offended in much the same way as my client, and even though some of them were given jail sentences, they didn't actually serve that jail sentence in a prison cell. I'll just sidestep for a moment. With imprisonment, there's varying forms in which it can be served. Obviously, going to jail is one of them. The next step back from that is immediate parole. So what that means is, if you're granted immediate parole, technically you've gone to jail, but the day of court's your release date. So on your record, you'll be seen to have gone to jail, even though you never set foot in a jail cell. And then during the parole period, you need to report to the parole board. So let's say you get 9 months imprisonment with immediate parole. You don't go to jail, but for the next 9 months, you need to report to the parole board to make sure you're on the straight and narrow and not reoffending. The next step back from that's what's called intensive correction order. Much the same as immediate parole, a little bit more regimented in the sense that they generally have more things for you to attend to, whether it's psychological counselling or if it's drink driving, urine testing, etc. The next step from that is a wholly suspended sentence, meaning it'll hang over your head for a period. So let's say someone gets 9 months imprisonment, wholly suspended. You don't technically go to jail, but if you play up for any reason that's punishable by imprisonment in that 9-month period, the imprisonment will drop down and you'll serve it. But I mean, that said, I've had clients in that position. I've managed to, again, avoid imprisonment, but basically that's what wholly suspended imprisonment is. And the next step down from that's probation, which isn't necessarily, well, it's not a punishment as such, it's a supervisory order. So the magistrate, given it's not a punishment, they can't order it without your consent. But if you consent to probation, they'll order it, and that technically, procedurally, it's much the same as immediate parole, but it looks a lot less worse on your history than obviously any kind of jail term does, whether you serve jail or not. And obviously, the magistrate, if they do see fit, can simply give a disqualification and fine only. I mean, there's community service and a few other various options available, but I won't go into those now. But again, I took my honour quite deeply into the written submissions that I'd made. I laboured the fact that even though he's got these 3 offences in a very short time frame, his history other than that is average, and there was this sort of chain of events that led to this offending were triggered by health concerns that I won't go into now. But it wasn't just a case of throwing caution to the wind. He had some trauma in his life, and his life sort of went into disarray, and he just kept stuffing up. But in any event, what I'm getting at, he didn't go to jail. He got a disqualification and fine only. I should add, there was also 2 other charges of contravened direction which had to be dealt with, but I won't go into those now because they're not particularly relevant to what I'm saying and what the outcome was. So, disqualification, it was 2.5 years. The mandatory minimum for first-time disqualified driving is 2 years, worst case 5. But I mean, there is a general power under the Penalties and Sentences Act for magistrates to give up to a lifetime disqualification. But he got 2.5 years. So given this was his third in 18 months, 2.5, given the minimum is 2, is very good. But again, my job wasn't about saving his licence. It was about making sure he doesn't go to jail. He got a reasonable fine given the offending and the history, and he didn't go to jail. So we all walked out of the courtroom together. He can't drive for 2.5 years, but he's not going to jail. He goes back to his job and his kids and gets on with his life. Needless to say, he's relieved. He was very, very, very worried about going to jail. Obviously, I made sure that didn't happen, and he gets to move on with his life and ideally not make this type of mistake again. Anyway, client's very happy. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road.